Hey guys, welcome to the HeirKare Podcast with Kathleen and Erik. We are estate planning attorneys with the firm Fowler Baker Shade in East Tennessee. We are here today to talk about the financial power of attorney, sometimes called a durable general power of attorney. Before we dig into some common questions, Erik, why don't you tell us a little bit about the document, what it does, and what it's used for?
Your general power of attorney is essentially something that's going to grant another person the ability to handle your financial assets or a set of financial assets, however you choose to cabin that in, on your behalf. There's a couple different types we use. We use ones where they're effective immediately, most commonly between spouses, especially if one's maybe traveling internationally or something, where the one who's still at home may need to deal with things at the bank or things like that. Or there's also ones that are springing, which we'll talk about a little more detail. But basically, that's saying, hey, it's only effective when I'm incapacitated. Only if I can't do things for myself, somebody else is going to jump in for me. Um, and it's generally speaking, it's a very broad grant of powers. The way I often explain it is you are standing in, or you're naming somebody who's going to stand in your shoes when they're standing at the bank teller counter, right? As far as the bank is concerned, once this document's cleared by their legal department, the person you've named is you to the bank. And so they're going to be able to do anything and everything you can do, they can do for you. There's generally, most states have a very broad statute that says, hey, here's all the powers that most people by default would want to grant under a power of attorney. But there are some powers that states say, hey, these ones not as often, so you're going to have to specifically say you want the person to have this power. Um, so Kathleen, I know you've done a little bit of digging recently into some specific of what those powers might be in different states. So you want to talk a little bit about that?
Yeah. So, for example, in Tennessee, if you want your agent to be able to have the power to give gifts to others or themselves, that has to be specifically stated. And the idea why that is kind of a little bit different is because the agent, whoever you've named, is your fiduciary. And we'll talk about what that is in a minute, but they have a responsibility to you to manage your finances. And it could be viewed that giving away money is actually a violation of that fiduciary duty. But there's sometimes we want to be able to do that. So that's a power that has to be specifically stated in Tennessee and a couple other states as well, as far as I'm aware. Another specific to Tennessee one is that if you want the person to be able to have access to your electronic communications, then you have to specifically state that as well. Georgia, for example, they have got a statutory form that they use, which I am generally a fan of. And maybe a little later I'll tell you why I like foreign powers of attorney. But they've got everything as a check mark box, like, hey, here's a general list of things. Do you want all of these or just certain ones? And then below that, there is a specific authorization. So this relates to things like giving gifts, same idea, the ability to make or revise existing trusts, um, change beneficiary designations. You'll see these types of let's say, stronger powers needing to be specifically designated across many different jurisdictions. So yeah, those are a couple examples of the general powers. Hey, go to the bank, pay my bills, have access to my credit card information, versus specific powers that need to be named and granted.
Right. Right. So, that we've kind of covered what the basics of what the document does. One common question that I know I get asked because people come into our office and there's all this legalese in front of them, and they tend to cherry pick words where they're kind of like, "Well, what does that mean? I don't know. What's that? I've never heard that." So often you'll see your POAs and say it's durable. What does that mean?
So being durable, meaning that in the event of your incapacity, the powers that you have granted your agent continue, right? They are durable, they're strong, they're not going to go away just because you lost capacity. And this seems almost a little counterintuitive because a lot of people might think, well, that's why I set up a power of attorney. So if I couldn't do it, I would want people to do it. Why are we restating it? And I totally get that thought, and it can seem a little duplicative. But there are situations in business where people grant more limited powers of attorney, and they can be used a lot of places outside of just personal finances and maintenance.
Yeah, yeah. Like I know while I was in law school, I interned at a real estate firm up in New York, and actually up in New York, it's very common because New York's both sides have to have their own lawyer state, so that like real estate closings, the lawyers are almost more involved than the real estate agents at that point. And it was very common for the seller's attorney to have the sellers come in even a week before closing, sign a power of attorney document, and then their attorney would go to closing for them and sign everything for them as limited power of attorney for purposes of this closing, right? And so that one obviously is not going to be
Yeah.
durable. We don't want it to be
Mhm.
durable, and so I think that the having to have this extra term, I think, comes from POAs are kind of something that estate planning has stolen from the business world, from agency
Yes.
law, and said, "Hey, we want this thing that they do over there. We want to do it here
Mhm.
too, except we want to do more
Yeah.
with it, right?" And so the durable is the part that lets you do that little bit
Mhm.
more there.
Yeah, and I
Hmm.
just speaking about us stealing documents from other areas of the law, this is considered one of the basic estate planning documents. And so, and I'll let you give your opinion here, Eric, but it's my opinion that this is as important as your will. Um, Having someone who is capable of helping you with your finances if you can't during your life. And so, can you tell us a little bit about um, why this is important? Some examples, maybe where this might come into play. Yeah, can you give us a few examples about that?
Yeah, so I actually regularly tell people these are actually the most important documents in your plan in the sense that they are the ones that are the most likely to be
Mhm.
used. They're also the ones in your plan that if you don't do them, the only alternative is a very, very, very expensive court proceeding, right? If you don't do a will, all states have an intestacy statute that is basically the state has given you a will, right? And the probate of an intestate estate versus an estate with a will, which is testate, cost wise is about the same. The cost of doing a power of attorney document's a couple $100 probably. Cost of a conservatorship proceeding is a couple thousand, right? So, and those incapacity comes up almost, especially as with medicine advancing where it is, comes up in most people's lives at some point that they're incapacitated, somebody's acting for them. So these documents are incredibly important. They're used very often, um, and they need to be tight and done well so that they can actually give the powers that need to be granted for when that comes up. Um, Really big one that I see a lot is particularly for younger married couples when if one of them is going into the military or something like that and they deploy, and then while they're gone, the Visa card ends up with fraud on it, right? And then, you've got a time difference to work around. You've got the fact that they may be out on patrol doing different jobs and stuff. They're not immediately accessible when the credit card company's customer service line is available, right? And so the spouse who's back home needing to handle that and the ability to just say, "Hey, where I've got a power of attorney for my spouse who's deployed. Where do I
Yep.
fax it?" Right? And then they send it in, and then they just
Mhm.
handle it. That's kind of one very common one. Another one is going to be um, one spouse. You start getting up more elderly. One spouse ends up having a stroke or something like that, and they need to go into a nursing facility. And there's this bank account that we kept meaning to add both of our names onto it, but we just never got around to going to the bank. We had it in the online banking altogether, so it didn't really matter. I always had access. And now all of a sudden they're incapacitated and we need to have some document that can let us actually go touch that money, right, and move it over. And so the power of attorney document really helps with just smoothing that process over. And I know you mentioned you really like using the statutory forms. So and so why don't you tell us a little bit about exactly how the statutory form maybe can be more helpful in doing all of that more easily?
So my preference, or I like when states have statutory forms, and here's why. When I started my practice, I was working in Maryland. There was different rules then around the financial power of attorney. And as fabulous as credit unions are to their immediate customers, it has been my experience that they are very difficult to work with from a professional standpoint because either they're smaller, which is why they can provide tailored service, but they don't have the same legal personnel to draw on for help in understanding what they are and aren't allowed to do. And then they become very resistant about not wanting to do it, right? And so,
Especially if they've never seen it done before. If this is new to
right,
them,
right.
they kind of freeze up,
Yep.
right?
And so I had a situation once where we had a validly executed power of attorney, and we literally spent thousands of dollars in attorney time having to go with the client to the credit union to get them to accept the financial power of attorney. And when there are state forms, and in some states, and I believe Maryland is one of them, the law was updated and it said, hey, if you don't accept this statutory form, it gives the customer trying to use a statutory form a right to recover attorney's fees if they have to go to court to pursue um, enforcement and recognition of that document. And so not all states have that, but when you have a uniform document that is used, it's more familiar to people generally, it's more uniform, and it's my just what I've experienced in my life and practice tends to be accepted a little more easily, which I'm all for. But on that note, lots of times another question we get is, hey, I signed my power of attorney. And for those where you've selected to have that power effective immediately, people say, should I go tell the bank now? And I actually do recommend telling the bank now because it is easier for you to walk in as a competent individual and say, hey, I want this person to have access to my accounts and my information, and I'm giving you this document. And yeah, if they have their own form they want you to fill out while you're there, you can do that, right? And that's just going to cut down on a lot of red tape. Um, in an alternate situation where you've lost capacity and your agent's coming directly to the bank themselves with the documents. It's just going to be faster and easier for you to do it than for your agent. So I think, yeah, that's kind of why I like statutory forms for those reasons. But I think, Erik, you also touched upon something that I think we can delve into a little more, and that is the idea that if we have a financial power of attorney, maybe then we can save money in having to go to court and get a conservatorship or a guardianship. Different states use these terms differently. So when we're saying either term, we just mean a court appointed order saying, or excuse me, a court order saying, hey, this individual no longer has capacity to manage either their own financial matters or their health matters or both. Again, different states deal with these things differently. And that actually removes someone's ability to make decisions for themselves. And there's a court order in place that grants that power to make those decisions to someone else. So, what are some situations where maybe that financial power of attorney, even though we have one, may not be enough, and our agent may need to go to the court and get a conservatorship even on top of that financial power of attorney?
Yeah, so the most common one that I've seen in practice has been there's some other third party trying to get involved in the principal's business. So this is your kind of stereotypical random caregiver who all of a sudden showed up and is taking care of mom, and next thing you know, they've moved into the house and are writing checks on the bank account, and you're like, wait, hey, hold up, I have power of attorney, and the power of attorney document doesn't prevent somebody else from also being power of attorney. It's saying this person is my agent, but it's not exclusive, right? Versus a conservatorship kind of throws down an order and says, look, nobody else gets to do this except the person that we've named. Um, and most states also have a statutory preference within the conservatorship statutes that says if you have a financial power of attorney, the person you've named is the first in line that we're going to look to try to be the
Yeah.
conservator. Doesn't mean they're guaranteed to be appointed, but there's a strong preference to appoint that person as opposed to somebody
Mhm.
else. Um, and so you throw the conservatorship in there usually to
Yeah.
exclude other people more so than to because you need to grant the power. So the where the POA can really save you some money is when the family's all everybody gets along, everybody gets yeah, okay. oldest brother lives right next door to mom and dad, sister lives in Texas, and youngest brother lives in Oregon, right? Everybody agrees brother who lives next door should do this stuff. Nobody's going to be trying to jump into the middle. So then we can appoint the oldest child and they can just take care of everything and never have to go through that process because they're also right there next door. Nobody's going to show up and take care of mom, right? um,
Yeah.
and so that's where it really can save you
Mhm.
some.
I think I'd like to take a minute to talk about financial powers of attorney in the context of individuals with special needs, because that's another time where you run up against younger individuals being able to benefit from this document, right? So if you have a child who is disabled and is becoming an adult at age 18, right, you lose access to their medical records. And let's say the nature of their disability is such that they have capacity and they can understand what they're signing, even if they can't read, right? If they can understand it and can be explained to them, you can sometimes continue to meet their needs and assist them using that financial power of attorney. When that's not going to be sufficient is number one, if they don't have capacity to sign themselves, right? Then you're looking at a conservatorship. But the other situation where it may not be sufficient that I've seen in practice is you have an individual who, because of the nature of their disability, they understand, then they know that they need help and they have the capacity to give consent, but they are also very easily influenced and can be manipulated by others. And there have been, fortunately, been situations where, a bad friend goes and abuses that person for their credit, right? And so they are that adult disabled individual um, has a bunch of debt that they don't even benefit from, right? So the only way to stop someone's ability from contracting on their own is through a conservatorship guardianship process. So I just think that's another time when those come into play. Not as frequently used, not as commonly known or understood, but just another time that those are beneficial.
Right. Well, and where the POA can be if you do have one. So let's say you have a situation where maybe somebody executed one earlier, had capacity, but as their condition progressed, they got to where they didn't, and then they became, susceptible to influence, and then we ended up having to go get a conservatorship. The fact that we do have a POA appointed with some powers as far as what they can manage can make it so that when we do that conservatorship, the conservatorship can be more limited in its scope, right? We can say, we're only going to remove the power to contract, but we're not going to say that management of the bank account has to be supervised by the court, right? We're going to say the power to change who owns the account is, but we're not going to always require you to come back and file accountings all the time with us because we know you, financial power of attorney, are going to take care of things, right? And so we can limit what we have to do in the conservatorship as opposed to a full blown everything in your stuff is now going to be in a court file, which yeah, it's under seal, but it's still in the courthouse in a folder, right? um, so it can help limit and restrict that down so that you only have to do what you need in the conservatorship as opposed to everything being under that
Yeah.
court order. Hmm.
And one thing I think we should touch on before we wrap up here is so okay, I've got a power of attorney. I've appointed Erik as my agent, and he is now my fiduciary, right? What does that mean? What responsibilities, what duties then, Erik, would you owe me in that situation?
Yeah, so fiduciary duties are actually again another area where we because this comes out of business law, it comes from it's the same terminology that you use for like shareholders that what that the board of directors owes to shareholders of a company, all that stuff. But it's basically they have an obligation to utilize the assets under their care and management for the benefit of somebody else. And in doing that, there's a whole host of, and I could go down a huge long rabbit trail on exactly what all the duties are, right? Probably more than we need to today. But I mean that kind of sums it up, right? They can't use it in a way that benefits themselves, typically, unless you specifically authorize them to do that, which in family situations often we do because that's where the gifting stuff comes in, right? Like if I've got, my parents' power, I hold power of attorney for my parents, for example, they would they give me a Christmas gift every year. They want me able to give myself a gift, even though technically that benefits
Yep.
me, right? there is some stuff that we play around with there, but generally speaking, you've got duty of loyalty. You can't go do something that benefits somebody else besides the principal, and especially not yourself as the agent. You got your general duty of care to adequately manage the assets appropriately. Often that means using an index investment account, things like that. I can't just go, put it all in a sack and bury it in the backyard, right? I've got to manage the things appropriately. And then I also have to generally, I'm going to safe harbor in and I'm going to go get good advice from attorneys, accountants, financial advisors to make sure that everything is done correctly. And all of those things that I think inherently we all just know, like, oh, I'm managing somebody else's money, I should do these things. They come out of the fact that you have a fiduciary duty to that person, right? That's where that sense of that's the right thing to do comes from.
Yeah.
So,
Awesome.
mhm.
All right. Well, that wraps up our walkthrough of the financial power of attorney. Remember, guys, this is just informational purpose. We are not giving anyone any legal advice here or telling you what or how to do anything. So we hope you join us for our next.
Go hire your own lawyer.
Yes, that's our
Go hire your own lawyer.
CYA language that the lawyers love. Next time, I believe we will be going through a last will and testament. I think we've made it up to that document. So see you next time.
Yes, we have.